It's not about judging. Mr. Gaur, the question here is not about judging. Perhaps Mr. Manavendra Mishra would also bear me out on this entire matter. The question here is this, and Mr. Gaur, somewhere down the line you've got it slightly wrong in terms of facts, and let me correct that. Manavendra Mishra, you can also come into the picture. And that is, as far as the summons, or rather technically they are not really summons here, it is pretty much a protocol that is followed, especially for those against whom the lookout circular is issued and it turns out that the attempt has been made to leave the country. It is an explanation that they would be providing before the Delhi Police Economic Offences Wing. So technically it's not really a summon per se. But having said that, the reason why it has come now and not in the month of May, because as I understand from my sources within the Delhi Police Economic Offences Wing, is primarily because the investigation reaches at some point, at some stage, and that is the reason why a status report is filed, and thereafter the lookout circular is issued, pretty much what is essentially done. Manavendra Mishra, is there a problem with it? Because I would largely not really focus on the matter that he has to come and explain himself on the very fact that he was leaving the country. That's not the issue here. The issue is largely some of the allegations that he faces at this point in time. Can this be dubbed as harassment, as Mr. Gaur is pointing out? Because clearly, if I look at this status report, it largely talks about 8 firms. At least what I could count is at least 6 firms where directly or indirectly Mr. Grover and his family have been named. So prima facie, do you believe that there is a case that stands out?
Look, let's be very clear on the procedural part. I think that's important to understand and appreciate, because there's been a lot of, I would say, different opinions about this whole lookout circular thing. Lookout circular is purely the prerogative of the investigation agency. The investigation agency in this case is EOW. There is no provision in the 2021 master guidance which sort of regulates lookout circular that a copy of it has to be served on the person, although there are multiple cases where parties have sort of raised it as an issue. What happens is when you have a lookout circular at the immigration is where you are stopped and you're taken to like the small room which is just behind. And from there, more often than not, you are asked to go straight to the police station, or the investigation agency, whoever has taken it out, is asked to come and sort of pick you up from there. In this case, what I believe has happened is that they were asked to go back home, and on the next day, a summons to appear has been given to them. Now, this summons is your regular Section 160 CRPC summons to come and participate or join the investigation. This summons is not a copy of the lookout circular as such. Coming back to the timing of it, whether this is harassment, it's not easy. See, whilst lookout circulars have been in the news for a while, it's not a straightforward job to get a lookout circular. There's a form, there are details, there are particular thresholds which have to be met out. All of this has to be submitted, and only after that it sort of gets approved. So in this particular case, it's very likely, and I believe that the intelligence suggests such, it is that when he was traveling in the first instance, there was no lookout circular. It's only in the recent times, given whatever additional material that would have come in the hands of the investigation agency, that they could have made out a case of a lookout circular in this particular case. And I think as far as procedure is concerned, there's a procedure to set it aside. There's a procedure to get travel permission. Travel permissions are being granted by the court with certain conditions which have to be met out. So I think what's important is to really look at whether there was any illegality as such, which doesn't seem to be the case at this point of time. Now, this is purely on the lookout circular bit. I'm not commenting on the merits of the matter because, again, look, it's the subject matter of a trial. I think everyone here is equivocal in saying that we are not the people who can judge. The job of the EOW is to put the facts on record, which we believe it has done. It's the job of the defense attorneys of Mr. Grover to prove them wrong. If they make out a case, the courts will quash it. If they don't make out a case, it goes into trial. And it's only at the end of the trial that you can really put a bullseye on someone, and not before that.
Okay. Sharath, I think so we've pretty much taken care of this entire controversy surrounding the lookout circular and what Ashwini Grover is essentially dubbing this as complete drama. And perhaps, Mr. Gaur, you've got the perspective on this. Sharath, if I can bring you into the debate on the allegations, purely on the allegations that have been leveled against Ashwini Grover. And if I have to go through the status report, this largely talks about the HR firms that have been linked somewhere down the line to Mr. Grover and his family members. Then it largely talks about the GST violation too, which again is another issue that we have not really heard anything from Mr. Ashnir Grover. And that is concerning because here they say that the Director General of the GST has already replied saying that fake non-existing vendor firms had raised invoices to the complainant company, which is BharatPe, received payments from the complainant company, that is BharatPe once again. And they say the alleged persons here, that is Ashnir Grover and others, submitted their response before the DGGI, wherein they had accepted the finding that some of these vendors are non-existent. So there is an acceptance that has been made by Mr. Grover before the agency here, that look here, these were fake vendors.
Right. In fact, I would like to start by commenting on a very disturbing and unhealthy trend which has crept in the startup ecosystem. And this is not one case. So there's another case where Info Edge has filed complaint against Rahul Yadav, one of the PropTech founder, and the amount is close to 288 crores. So this is a very disturbing trend, and it brings a lot of disrepute to the world's third largest fintech and startup ecosystem, right? And McKinsey says that by 2030, the total revenue which fintech ecosystem can bring can go as high as $70 billion. So I think this is the right time. We have to set the right standards, and we should idolize the right entrepreneurs, right? And this is where a lot is incumbent upon all startup founders to set high benchmarks with respect to corporate governance. And this is a classical case of misgovernance, right? So startup misgovernance and a lot of financial irregularities, how they have managed to creep into the ecosystem. We also have to have a deep look in this matter and work towards how we can make the ecosystem more transparent and more inclusive for all startup founders.
Mr. Dua, would you agree with what Sharat Chandra is saying, that perhaps this is the classic case of misgovernance too? And of course, there is a corporate rivalry that comes into the picture. I'm not getting into it because that's not the subject matter of our debate. But as Sharat is also pointing out, do you believe this is a case, Mr. Dua, of also misgovernance?
Prima facie, there is. That, whether it's substantive, it can stand the test of investigation, and subsequently, because of the trial, time alone will tell us. So unless there are serious allegations made, the police would not have done what it did, that is, issue the lookout notice and subsequently send him summons. So on the face of it, it does appear to be a case of misgovernance, particularly when a couple of things which are, I think, to my mind, a little somewhat damaging against him. One is that the payments to be made to recruitment companies which have opened up their bank accounts subsequent to the dates of making the payments. So prima facie it appears. I'm using the word prima facie repeatedly just to mention that it's nothing established. Establishment is in a court of law, but when the police, from the allegation, turns it into a charge sheet, then it means the police is convinced about it, and that will be at the end of its inquiry. That's not yet happened. So once you, on the face of it, you have such serious allegations, and the fact that this has happened seems to have been also admitted before the GST authorities, it does lend credence to the allegations against him, and I would say that there is no harm for the two accused persons to cooperate. Let this inquiry be completed as early as possible, and if they have a credible story, I'm sure the police would have no reason not to believe them, particularly if they can also cite, police can get evidence to support saying that if there is a mistake, it's inadvertent, and that for inadvertency, the charges are civil in nature, damages to be paid, penalties to be paid, etc. But if it is deliberately, there is malfeasance, which is deliberate, I think then it's a criminal case, and that the police would have to decide as they move on.